Welcome, everyone. My name is Andrew. This is my dog Biscuit, and we are here to present the Florida review for the bar exam. And the Florida bar exam is notoriously difficult. There's the essay section and the multiple choice section, and I'm going to try and touch on everything. So get your pens and pencils out or your computers out, and let's try to learn proactively. If you can have a really valuable session tonight where you're paying attention, I think this can be a great experience. Angie, can you message Shelby and tell her to join? I just realized she's not here and she should be here. Okay, so I am going to start the presentation and I see you talking smack in the chat. It's all good. I can take it. All right, let's start with commercial paper. This is everyone's favorite subject, right? So what is commercial paper? Commercial paper is a negotiable instrument. So it's not cash, it's not securities, it's not a stock or a bond. It's an IOU, a promissory note, a check. It's a medium of exchange for money. So a note is a two-party instrument and a draft is a three-party instrument. A note would be a maker and a payee. A draft would be a drawer, which is pretty much the same as a maker, the person who writes it. A drawee/payor, which would be the bank. The drawee in relationship to the writer, and the payor in relationship to the person who's getting paid on the instrument. So in this situation, we have a note, which is a two-party instrument, and a draft, which is a three-party instrument. We could have order paper or bearer paper. The distinction is that order paper is to a particular person. So if it's to Tommy, that would be order paper. If it's just a cashier's check or something that whoever holds could properly present for payment, then it's simply bearer paper. So what is a negotiable instrument? What makes it negotiable? A signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or a definitive time to order a bearer with no additional undertakings. That's what we wrote right here. A signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time with no additional undertakings. It actually should include the word unconditional here. A signed, written, unconditional promise. And that actually might be the most important piece because they like to test that on multiple choice. They'll give you an instrument that says, this promissory note is from Andrew to Tommy for $500 on the condition that the Dolphins win the Super Bowl. That would make it non-negotiable because it has a condition. Or if it said, Andrew to Tommy, $500 on June 7th, but it was oral, well, then it's not written. If it was an actual solid instrument, but it wasn't signed, it wouldn't be negotiable. These are the essential elements of negotiability. Okay, so how do you negotiate something? Well, if it's order paper via authentication, so signing the instrument, and if it's bearer paper, simply via transfer of possession. What will they most likely test when it comes to commercial paper on the exam? The concept of a holder in due course. What is a holder in due course? It's the same elements as a bona fide purchaser. Someone who takes for value in good faith without notice, right? So a holder in due course is free of the personal defenses and only subject to the real defenses. So when you think of personal defenses, think of contract defenses, like lack of consideration or, no meeting of the minds. And when you think of real defenses, think of defenses on the instrument itself, like alteration or, fraud on the actual instrument. So a good way to distinguish between personal and real defenses when it comes to a holder in due course would be fraud in the inducement is a personal defense and fraud in the factum is a real defense. So if you can kind of put that in your mind, that a holder in due course is someone who takes an instrument for value, they pay for it in good faith without notice, right? So that's what a holder in due course is. And then there's presentment warranties and transfer warranties. So presentment warranties are warranties that the presenter of the check has when they go to get paid. And transfer warranties are warranties that the person has when they transfer the instrument from one person to the other. So that's pretty much the essentials of commercial paper. You want to know, it's governed by Article 3 of the UCC. A note is a two-party instrument. A draft is a three-party instrument. Order paper is to a particular person, and then bearer paper can be to anyone. Try to remember signed, written, unconditional, promise to pay a fixed sum of money with or without interest, on demand or definitive time, with no additional undertakings. If you can just remember that the conditional one is the one that they test the most, then that should really help you. Has it been properly negotiated, right? Authentication via signature, and then the holder in due course. They really like to test that. Someone who takes for value in good faith without notice. And then this piece, the shelter rule. So the shelter rule is like, if someone is a holder in due course and then they transfer it to another person, but not for value, so they didn't take it under the conditions of what a holder in due course should, they still can take shelter in the upstream status of a holder in due course. So that's called the shelter rule. It happens in property too with the bona fide purchaser. It looks like we had a question in the chat. Let's see. Okay. If there's a personal guarantee, it's still commercial paper. Yeah, a personal guarantee would still be commercial paper. On the exam, just think of commercial paper as this check and try to see if it satisfies all the conditions of negotiability. Okay, let's talk about secure transactions. Does anyone have any questions about commercial paper at all? Pretty solid. It's don't get weighed down in commercial paper. It's a subject that you can do well in if you just know the basics, and I think I just went over them. Okay, let's talk about secure transactions. So secure transactions are governed by Article 9 of the UCC. What are the key testable points when it comes to secure transactions? It would be the types of collateral, the concepts of attachment, priority, and attachment, perfection, and priority. And then the PMSI. So pretty much everything that's on here, these are just simple subjects that you can really master. People are so scared of commercial paper and secure transactions, but if you just understand, the basics of them, you'll do just fine. So secure transactions is Article 9 of the UCC. And the different types of collateral would be like tangible versus intangible collateral. And there's 4 different types of tangible collateral: consumer goods, equipment, inventory, and farm products. And you want to make sure that you know all of those different types of collateral. So we have the security agreement. What is a security agreement? The security agreement is what gives the lender rights in the collateral. So think of attachment via security agreement. That's like the agreement that identifies the collateral, identifies the lender and the borrower, and states the terms, but it's just between those two parties. It doesn't need to be filed with the state or anything. Perfection is done via financing statement, and perfection is done with the state or the county or whatever. And that's what puts others on notice that you have this interest. So that's why attachment gives rights in the collateral, and perfection puts people on notice and determines priority. So PMSI, a purchase money security instrument. A PMSI is when the money that is borrowed is used to purchase the collateral itself. And that, if it's a consumer good, automatically gives the lender top priority in terms of perfection. If it's a non-consumer good, there's a 20-day grace period after attachment where they can perfect anytime within those 20 days and they'll have priority. But just kind of remember essentials on this test. Let's think of it as a low-hanging fruit test. This is a low-hanging fruit review. Secure transactions, let's just know what a security agreement does. It gives rights in the collateral, and let's know what a financing statement does. A financing statement determines priority, and it's what constitutes perfection. So when we're looking at priority, who's going to prevail? Well, if it's perfected versus perfected, it'll be first in time, first in right. If it's perfected versus unperfected, the perfected priority will always prevail. The PMSI will have super priority, and then if it's, you know, unperfected versus unperfected, it would just be the first to attach, first in time, first in right. So perfected always will prevail against an unperfected interest, and then otherwise you can pretty much go with the general idea of first in time, first in right. Secure transactions in commercial paper, I think I just did it in 7 to 8 minutes. Pretty high level, fundamental, promissory notes, interest and collateral. Any questions about the two hardest subjects on the exam? Not to make light of them, but like, let's just keep it high level. Any questions about them? When you see these questions, just, you know, stick to your guns. Is it a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order bear with no additional undertakings? Okay, if it doesn't have one of those elements, then it's not commercial paper. And then for secure transactions, look at, did they attach via security agreement? Did they perfect via financing statement? Is it a PMSI? Did they use the loan to purchase the collateral itself? Now, sometimes you can attach or even perfect just via control or via possession, and it's pretty logical. Like, if it's an account, then you can control it. If it's you know, something that you could possess, then, you know, you could possess it, right? If you have actual physical possession of it, then that would most likely give you priority because you could show that you actually have it, like a check, maybe that'd be something that you could possess. So that's that. All right, let's talk about trust. Again, I think starting from the bottom here, these are subjects that are like not heavily tested, but you know, if they are, you want to be ready for them. So we talked about different types of trust when we played our Jeopardy game. I remember that mnemonic, like Trissy Dunks that Will came up with, testamentary trusts, right? Inter vivos, well, testamentary trust, revocable trusts, inter vivos trusts, spendthrift trusts, inter vivos trusts, discretionary trusts, mandatory trusts, oral trusts, no contest trusts, which are not valid in Florida, charitable trusts, secret trusts, and then semi-secret trusts, which are not enforceable in Florida. A secret trust is mentioned in a will with beneficiaries. A semi-secret trust is mentioned in a will without beneficiaries. They like to test the elements of creating a private trust. I think SIT-TAPS is the mnemonic we had. Settler with intent, trustee, trust race, ascertainable beneficiaries, and a valid purpose. Real property and testamentary trust must be in writing. Makes sense, right? Statute of frauds. Precatory language, like I hope that, it's my hope. I would like to set up a trust. That's not sufficient. It has to be true intent to set up a trust. This is a great statement to think about. The hallmark of trust creation or revocation is settler intent, meaning well, how should this trust be modified, or should this trust be revoked? Well, what would the settler have wanted? Because the settler is, the grandfather who created this trust for the grandkids. Well, he would want them to go to college. So yeah, we'll amend it because the price of tuition went up and actually, you know what I mean? Like things like that to align with settler intent is the best way to approach these questions. Inter vivos trust, what created while the settler is alive, that's opposing a testamentary trust, which is created in a will or created upon death. Charitable trust, they really like to test this, the Cypress doctrine, meaning if we have a trust that's gonna go to the American Cancer Society, but by the time the trust is due to distribute, that society has folded and is no longer. Well, under the Cypress doctrine, we could still use the trust corpus or the trust race or the trust property to pay out a similar charity that would have matched the settler intent. Remember, the hallmark of trust creation or revocation or modification or disbursement or in general is settler intent. A pour over trust is a gift to an inter vivos trust. So usually it's created in a will, like anything left over in a will pour over into a trust. And then spendthrift provisions, heavily tested. So I always associate this guy Chet Hanks with spendthrift provisions. That's Tom Hanks's kid, and he's like the rapper, and his other kid Colin is like the goody two shoes. So let's say Tom Hanks probably made a lot of money off of like Forrest Gump and that movie where he was like on the island with coconuts and stuff. A lot of movies, right? He had an illustrious career, made a lot of money, sets up a trust for his kids. Now, Colin, he's probably not worried about. Chet Hayes, as he goes by in the hip hop world, he might actually be worrisome. He might spend his money not in the most meaningful ways. So how could you compensate for that, or how could you take that into consideration? It would be a spendthrift provision, which makes it so that Chet Hanks's creditors couldn't pierce the corpus of the trust. They would have to wait until disbursements have been made to attach. So that's what a spendthrift provision is: a trust that restrains both voluntary and involuntary transfer of a beneficiary's interest. There are certain, super creditors that can pierce a spendthrift trust. For example, alimony, child support, or government taxes. Okay, let's see what we got in the chat. So let's see. I feel like none of this is going to be valuable, but I can try to read it. Erica or Attorney Adam, as a Philly area guy, Andrew probably knows all about Cypress and the Barnes Museum Foundation. I really don't, honestly. And then you're saying Castaway, and then you're saying Big. These are Tom Hanks movies. And then someone group texted me, and then Philadelphia Lawyer movie, okay, and then Splash and Bosom Buddies for the really ancient mothers. All right, I feel like I haven't learned anything from that chat. Okay, so now we have talked about commercial paper, secure transactions, and trusts. I trust that you've learned something. Has everyone learned at least one thing today, or you guys have known everything I've talked about? This is just review. Either way, it's a good sign. If you're learning something, that's good. If you're learning nothing, then that's good too. That means you know most things. Angie, I tried to text Shelby to come, and I know you tried too. She said she's studying. At the end of the day, I like when people are locked in, and me and her have been working hard, but I do wish she was here. I feel like this is valuable. Okay, so Crim Law, Crim Pro. This is kind of a strange slide. I'll talk about it, and then I might jump off the PowerPoint for a quick second. Let's just see what we got here. So types of crimes: capital felony, life felony, first degree felony, second degree felony, third degree felony, first degree misdemeanor, second degree misdemeanor, and then You know, you can have like municipal violations or things like that. So I like this statement right here. Homicide is not always a crime, but the act of murder is, right? Like there's excusable homicide for sure. And then not all homicides are murder, right? But all murders are homicides because a homicide could be manslaughter or something of that nature. So in Florida, we do recognize first, second, and third degree murder. First degree murder is premeditated or felony. Second degree is depraved heart or accomplice to felony murder. And then third degree would be during the commission of a non-enumerated felony. Like maybe it's your third time getting a DUI and you run over some kids. That would be third degree murder in Florida, potentially. You know, again, prosecutor, defense, they'll argue different things, but there's an argument for that. Defenses include excusable homicide, justifiable homicide, and self-defense. Florida's adopted stand your ground laws. Manslaughter, there's manslaughter by act, like you do the thing, and then manslaughter by procurement, you create the situation that leads to the death. And then involuntary is manslaughter by culpable negligence. So voluntary manslaughter, think of adequate provocation. You know, maybe you walk in on the pool boy and your husband and you shoot them. Well, that would probably be adequate provocation. It could also be like imperfect self-defense. You know, someone is fighting you with their fists and then you defend yourself with the Colt 45, right? Like that might be a little bit imperfect, and that would constitute voluntary manslaughter. Criminal law, criminal procedure is interesting how it's tested in Florida. It's usually supposed to be crim pro is a multiple choice subject, but they do test it a little bit on essays. So just kind of be prepared and understand mostly everything. So criminal procedure, and again, I'm just going over some high level things like the outlines I have in the classroom, especially the ones by Joel, I think are fantastic and you can really go through them deeply, but I'm just trying to go through some high level points tonight. So felonies, any criminal offense punishable by death or incarceration in state correctional facility for over a year. A misdemeanor is any criminal offense punishable by incarceration not exceeding 1 year. There could even be something that's punishable by like detainment in a, you know, municipal or city center that wouldn't be a misdemeanor or felony. So it has to be like, you know, a crime. So defendant can plead, and this would be like at arraignment, not guilty, guilty, or nolo contendere, like no contest with the consent of the court. They could also potentially do like an Alford plea, which pretty much is a guilty plea, but saying that you didn't want to plead guilty, kind of like snitching. Stop and frisk is permitted in Florida, including strip searches. So, you know, stop and frisk is pretty much like a Terry stop where if they have reasonable suspicion that criminal activity is afoot, they can pat you down supposedly for weapons. But then if they find anything that, you know, is illegal, then they can continue the search. So then there's a process of first appearance where you're notified of the right to counsel, the charges, your right to remain silent, right to communicate with others, and you're advised of conditions of pretrial release. You know, if you've been arrested without probable cause, then you could be entitled to a non-adversarial probable cause determination hearing, or if it's a felony and you've been in custody for up to 21 days, then you would be entitled to an adversarial probable cause determination hearing. These are all like rights that the individual has when they're arrested. Most times people are arrested, well, I don't know about most times, but a lot of times people are arrested under warrants or probable cause. So you don't need that determination hearing. That's if you're arrested without probable cause, without a warrant. So the voir dire, examination of the jury, they may be challenged for cause. Peremptory challenges are available, but not for like race or gender. the word sua sponte, an act of authority taken without formal prompting from another party. So usually sua sponte means the court on its own initiative, they decided something. An arraignment, that's when the defendant responds to formal charges, like I plead guilty, I plead not guilty. A lot of times first appearance and arraignment happen back to back in the same procedure. And then sentencing guidelines are based on the criminal punishment code, and then contempt would constitute disobedience toward the court. So direct is in the court and indirect is out of the court. I really think when it comes to crim law, crim procedure, when it comes to the essays, you want to know like Fourth, Fifth, Sixth Amendment, and I think I'll talk about this a little bit later in the presentation, but like warrants, Miranda rights, exclusionary rule, fruit of the poisonous tree doctrine, things like that. When it comes to the multiple choice, you want to know about like the defendant's rights when they're arrested, when they're in a lineup, when they're there's probable cause, when there's a warrant, when there's no probable cause, right to a jury, who constitutes the jury, the actions of the judge, like procedural things. So they don't typically test so much on like elements of murder and burglary and robbery and larceny and things, but they could. Now in Florida, they're all theft crimes. There's a website that I've never taught you this before, that I really think is a great website for people to go to. His name is Hornsby. So if you go to hornsby.com, this guy right here, and you go to like Florida crimes, he does a really great job of just telling you what all the crimes are. See, they're all called theft crimes in Florida. They're all listed under theft, and like homicide, there's first, second, third degree murder. I really like this website by Hornsby. I've been using it for years. I think it's a great resource. And another thing that I'll share with people right now, I just shared that on the website. If everything that I said to you about commercial paper kind of went over your head, there's a website that I'm giving you all right now too that I think I remember when I was studying, I read this guy's website. I was like, oh, this was super helpful. So just kind of giving you all some resources that I use. Yeah, right here, sailor.org.github.io. He does commercial paper and secure transactions. He has some great graphs. He's got a whole bunch, takeaways, exercises. I mean, there's multiple sections. He does like holder and due course, types of commercial paper, requirements for negotiability. I mean, if you're really anxious about these subjects, which I don't want anyone to be, I would recommend going to this website. So just some additional resources for people. Hornsby for crimes and Sailor GitHub for commercial paper and secured transactions. Those are some helpful resources that I remember. Okay, so business entities. This is a section that I worry about. And just give me 1 second. How's everyone doing out there? Does anyone have any questions about anything? I'm just gonna eat this cookie. Yeah, go ahead, just take a second because I need to eat this cookie right now.
Okay, I have a question about the sentencing phase. So on multiple choice questions, I've seen where a judge either will give a sentence outside of the guidelines, and sometimes it seems like when they do that, it needs to be with written reasonings or findings as to why, if there's a deviation. Other times it seems like it's just subject to a motion by the defendant regarding the sentencing, and there is no time limit, especially if the deviation is above maximum.
Yeah,
Am I misunderstanding?
no, you're saying it perfectly, that that's how you would bring it up the first way, like on motion. And then it is true that if they well, I mean, I meant the first way the judge is allowed to say that, or maybe they could deviate with written findings. That's true. But also, if the defendant is sitting in jail and his lawyer's like, wait a minute, they sentenced you to longer than they were allowed to, you're allowed to bring that up at any time. So that's what that means in that regard, that the judge could potentially deviate from it if there's proper reasoning and he gives findings and all that. But if you're bringing up a motion to vacate for excessive sentencing, that it went beyond what you were able to be sentenced for, then you actually could bring that up at any time. Okay, does anyone else have any other questions about anything? All right, cool. I was just trying to eat this cookie. That's a good question. All right, let's talk about business entities. People struggle with business entities, because I don't know. I guess you guys don't care about making money. You just really care about the law and justice, and you didn't go to law school to make a career and start a business. You went to law school to defend honor, and I get that, and I'm really proud of you all. Me, I like this money. I like business entities. I like talking numbers. I like seeing how things work. So this is a subject on the exam that interests me the most. And I recognize that most students do not like it and they don't do well on it. And that's a shame because I think it's pretty likely to be tested. I'd say the likelihood of it being tested is like 68.7%. So let's talk about business entities, corporations versus partnerships. I feel like that's the reason Shelby didn't come to class tonight, because I asked her what the difference was last class. So corporations are separate entities, and they're subject to double taxation and have limited liability. They have shareholders who are stockholders who have interest in the company. They have common stock or preferred stock. Common stock have voting rights, which include voting for the board of directors, voting for fundamental changes in the company like mergers, consolidations, stock splits, amending the corporate charter. They have derivative rights. They have the right to sue directly. So derivative rights mean to sue on behalf of the law of the corporation. Direct rights mean the right to sue the corporation directly. They have anti-dilution rights, meaning that their proportional stake in the company is at least subject to a right of first refusal. That's common stockholders. Preferred stockholders have dividend priorities, so they get dividends when declared ahead of common stockholders. They use this word cumulative on the exam. They like to test it when it comes to cumulative voting. That's for common stockholders, and that means that you could stack your votes for one spot on the board of directors, and it benefits the small time investor. Cumulative preferred stock, cumulative rights mean that preferred shareholders get paid all of their dividends, even for years that were not paid in arrears in the past, before common stockholders can get paid out. So corporations are these entities that, have limited liability, meaning the shareholders can only lose what they invest, and they're subject to double taxation, meaning they're taxed at a corporate level, and then they're taxed again when the shareholders sell their shares, because they'll have to pay capital gains tax. So most corporations that are big corporations at least start off as a C corporation. They can elect to be an S corporation, which would be a corporation that elects flow through taxation. Just like an LLC is like a partnership that elects limited liability. It said LCL, that's why I had to change it, and I couldn't figure out how to edit it. So you'll see that was the one change I made to this PowerPoint. So corporations are subject to double taxation. Partnerships are flow through entities, and partnerships, at least general partners, have unlimited liability. So, if Tommy and Johnny just start business together, they're going to be subject to unlimited liability as general partners, even in the absence of a partnership agreement. Corporations require formal, registration with the state, and if they're going to issue shares, it requires formal registration with the Securities Exchange Commission. Remember, if they use the word blue sky laws, that's going to apply to intrastate transaction securities issuances, meaning within the state. That's blue sky laws would be within the state. Interstate would be the SEC, the Securities Exchange Commission. So LLCs and S corps are very similar. One of my students, I don't know if she's here tonight. No, but she's in my boot camp. She was telling me about her S corp for her like TikTok makeup nail business. And we were talking about, my business is an LLC, hers is an S corp, and I'm like, honestly, it's more advantageous for me to be an S corp. There's some tax reasons, and as an S corp, you could potentially issue shares. But on a fundamental level, they're very much the same. They're elections. C corps that elect to be S corps are electing flow through taxation, so they have flow through taxation and limited liability. And then LLCs are partnerships or sole proprietorships or whatever it may be that elect limited liability. So they have flow through taxation and limited liability. That's the same with an LLC, an LLP, and an S corp. A GP, a general partnership, means that there's all general partners. An LP means that there are, there's at least one general partner, and then there could be, one or more limited partners. A limited partner has limited liability. So that's pretty nice. An LLP means that they're all limited partners. But even in an LLP, a limited partner would still be liable for their own malpractice. So general partners have management responsibility and personal liability. Limited partners are only liable to the extent of their investment. They like to test this a lot, the concept of piercing the corporate veil. So this means either going after the corporation's board of directors directly, or if the corporation has a subsidiary, it means piercing that subsidiary and going after the parent corporation. Piercing the corporate veil usually happens if there's improper conduct, alter ego, proximate cause. We could see evidence of this being if they're just a shell corporation or inadequate capitalization, meaning like they created this company with $10 and they were allegedly going to sell like rockets or something, like that's a pretty extreme example, but yeah, clearly they were just defrauding investors to get the money so we can pierce the corporate veil. You're looking for bad faith and bad conduct when it comes to that concept. A quorum is the majority needed to validate an action. So a quorum means how many directors do we need to have a vote? In the absence of language to the contrary, it's usually a majority. Like if there's 12 people, we would need to have 7 people there to have a vote, and then we would need to have 4 of the 7. But they could tell you language to tell you what would constitute a quorum. I just talked about earlier straight voting versus cumulative voting. Straight voting means like, let's say IBIS PREP, we have the board of directors and 2 chairs are open, and Tommy has 10 shares, 10 votes. Tommy would have to vote 5 votes for one chair, 5 votes for the other under straight voting. Under cumulative voting, Tommy could stack all his 10 votes for one chair, and then all the little Tommies in the company could stack their votes for that one chair, and then all the little Tommies in the company could elect Tommy the Tommy guy, Tommy the Tommy gun, and Tommy the tool man, and then they could have representation. So that's why they say that cumulative voting benefits the small term investor. A lot of this stuff is very semantic or procedural. Like there's a concept that they test about a voting trust. A voting trust is just people agreeing to lock their votes together and have one representative vote on behalf of all of them. You can also vote by proxy, meaning that you're voting like remotely, like by telephone or having someone vote in your place. Merger is when one company acquires the other. So think of like Pac-Man, like a merger, one company survives, the acquiring company acquires a target company and survives. And then a consolidation is when 2 companies combine into a new company. I mean, there's so many things I could get into with business entities. I just think like, imagine you are the business and just answer the question like, okay, who would be liable here? Remember the business judgment rule. Same thing with the trustee. It's the same concept. Like they're not going to be liable for things that they use their best judgment. Okay, I elected Tommy. Let's use a new person. I elected Susie. Well, it's not let me ever be accused of anything. I elected, what's the most androgynous name I could think of? Uh, what's my neighbor's name? Oh yeah, Charlie. I elected Charlie to run my company, and Charlie invested in Bitcoin, and Bitcoin went to pretty low. Is Charlie liable for a violation of the business judgment rule? The answer is probably no. As long as, it was reasonable to invest in Bitcoin, a lot of big firms were investing in Bitcoin. Like that's, he has the benefit of the doubt. Same with the trustee. What if they invested the trust assets in Bitcoin? Same thing. We're probably going to say, hey, if he, had sound financial advice and they told him to invest in these magical coins, then it wouldn't necessarily just a diminution in value represent a violation of the business judgment rule or trustee duties. So, just some kind of similar concepts that we can think of. All right, anything else I can think of with business entities? I talked about blue sky laws. I talked about all right, what about like Dodd-Frank Act or Sarbanes-Oxley? These are some laws that were passed. I just feel like laws could be tested on the law test. So what were they? Dodd-Frank and Sarbanes-Oxley? They were just laws that were passed that made it so that corporations had to have strict accounting and disclosure requirements. Like you couldn't just have a company that was saying you're making all this money and you were really being Enron, or you couldn't have all this you had to have a compliance coordinator. So that's why I keep saying I wish Shelby was here. She works now as a compliance coordinator. I'm like, your job was created via this litigation, Dodd-Frank and Sarbanes-Oxley. And then maybe like the acts of 1933 and 1934, those were just acts that created the SEC and required a truth and disclosure, meaning if a company is going to go public, like an IPO and an initial public offering or something, they have to issue a prospectus, which is a piece of paper or a disclaimer that tells everyone, what's up with the company, how much is it valued, and things like that. There could be promoters, people who are like trying to sell the shares, and they could be liable personally, not just for the contracts in promotion, but also the contracts after the company's been formed. You kind of want to know like how corporations cease and how partnerships end, like when a partner, dissociates, he could still be liable for things that occurred during the time he was there, or, things like that. On the test, tend to pick the answer for partnerships that says like both partners can be liable because, the third party wouldn't have known that they weren't partners, right? It will be an apparent agency or an implied agency theory. All right, I don't want to spend too much time on business entities, but I think that was pretty solid. All right, what about wills? So wills, Marion, someone, Kaylee, you're working with Marion? I think she's in the chat.
Yes, I'm currently working with Marion.
She got a perfect score on wills on the multiple choice.
Yes, and she's made me feel a lot stronger in them.
I bet. I tried to pick her brain a million times. Like, how could you do that? But we're really getting this down to a science. Barbara got a 28 or 29 out of 30 on Florida Civil Procedure. Amy scored almost perfectly. Rebecca's scores were insane. Joelle's scores were really top notch in Florida multiple choice. I used to be like a huge advocate of essays, and I thought like I had essays down to a science, and I thought Florida multiple choice was kind of like a nut we couldn't crack. But I feel like we really are starting to crack it. We've given all of our students tons of practice materials, and some of our tutors and students have gotten near perfect scores. So I really think that you can do better on Florida multiple choice than you think. But at the same time, when you walk out of there, you're not going to feel good about it. It's a really dense test, and they test a lot of nuances, and the passing score isn't high. So when you walk out of there and you don't feel good about it, just know no one else felt good about it. The essays is really how you should kind of gauge yourself. If you wrote 3 full essays, that's a really good feeling. You know, if you only wrote 2 and were bullet pointing the third, that's, you know, what we're trying to avoid. So try to be mindful of your time more than anything. Try to properly allocate, you know, 1 hour per essay, or if you have extended time, 1.5 or 2 hours per essay, whatever it may be, try to truly allocate your time accordingly. Okay, so will formalities, let's talk about wills. So wills, signatures by a testator with the intent and capacity and 2 subscribing witnesses. Florida intestacy laws transfer property per stirpes, which are divided by equal representation of the original surviving issues. So A and B are married, B dies, A survived by C, D, and E. E's also dead. E has F and G as children. Well, now B surviving, C, D, and E get 1/3. E's dead. E's kids F and G will each get 1/6. So we'll go 1/3 to C and D, and then 1/6 to F and G. If you followed me on that, power to you. But that's what per stirpes means. A codicil is like an amendment to a will, right? It has to comply with will formalities. It supplements a will but does not replace a will. Just know that if you write one will and then you replace it with a second will and then you revoke the second will, that doesn't automatically revive the first will. And then in Florida, we do not recognize partial revocation, so you can't just cross something out in a will. You also cannot put any dispositive, meaning disposal of property, meaning distribution of property, beneath the signatures. The signatures need to go beneath all the dispositive parts of the will. Florida will not recognize a holographic will, so handwritten will. I mean, we will recognize a handwritten will that complies with will formalities if there's 2 subscribing witnesses and all that. But if it's just simply a person handwriting a will, obviously we're not going to recognize that. Not obviously, some jurisdictions will, but not Florida. We will recognize wills that were validly recognized in other jurisdictions when they're created. So if you cross out a section of the will, doesn't it invalidate the entire will? Can someone confirm me or correct me? No, that's not the case. If you cross out a section of the will, you haven't done anything. You have to do a complete revocation of the will. You can't just do a partial revocation. And when you do the revocation, you have to have the intent to revoke it and the actual physical act. It can be at someone else's direction. You can direct someone to do it, but they have to be actually there present, and you have to like tell them to revoke it. Ademption versus abatement. Ademption means it's been deemed. So Tommy wants to give his estate to his kids, and he gives Johnny the Mercedes. But you know, at the end of his life, he ran upon Susie, and he gave Susie the Mercedes in exchange for company. Now it's been deemed. It no longer exists in the estate because it was gifted to someone else. Whereas abatement is a diminution in value. So if you have an account worth $1 million, and you know, now Susie likes to go out and gamble, and now that account is only worth 500,000, and each kid was promised 250,000 each of the 4 kids. Well, now they're only going to get 1/4 of the 500,000 instead of 1/4 of the 1 million because of the abatement in the account. So that's pretty cool. Florida recognizes the spouse's right to take from the estate 30%. It's called the elective share. So in Florida, let's say you know, Tommy running around town with Susie. Tommy's 90 years old, Susie's 22, and they're having fun, and Susie's got this plan to take all his money, and Tommy thinks he's smart, and he's gonna write a will and give his will to like his friend Jack. Well, what happens? Tommy dies, Susie is left with nothing because it was all left to Jack. Susie, as the wife, let's assume she's the wife here, will be able to take 30% before any distribution under Floor's elective share. So you really can't write your wife or your husband out of a will. You have to truly divorce them. If you die intestate, the presumption is your wife will take everything unless you're survived by children from a previous marriage, then it'll be split between the wife and those kids from the previous marriage. And then if you have a will, you can devise as you may. Remember that a JTROS will prevail over a will. So if two people, let's say Drake and Kendrick, have a property together and it's a JTROS, but then, Drake drops a diss track and Kendrick drops a diss track and now they hate each other. So they write in the will to give their share of the property to J. Cole, I guess. It wouldn't matter. The JTROS would prevail over the will. Florida is a state that recognizes per serpes distribution, and wills questions can be tough, but just read them carefully, think it all the way through, and maybe draw it out, XYZ, draw the little arrows, and just be like Marion and just get a perfect score. Okay, civil procedure. So this is a solid slide. It's a lot of dates. Complaints, you have 120 days. Pretty much everything you have 20 days to respond. The answer, the pre-answer motion, the reply, the amended pleading, the answer to cross or counterclaims, impleader. Those are all 20-day dates. Substitution of a deceased party is 90 days from notation of their death. You can substitute them for another party. Depositions have 30 days. Interrogatories, 30 for the plaintiff and 45 for the defendant. Same with admissions and requests and examinations. And then a speedy trial in civil would be 60 days for an expedited trial. Some other dates we could look at are involuntary dismissal, right, would be 10 months plus 60 days of no activity. Summary judgment, 20 days for the plaintiff, from after the answer. Well, yeah, or anytime for the defendant after discovery. Settlement would be 90 days after service, but 45 before trial. And then motions, 15 days for to set aside or judgment notwithstanding the verdict. Motion for new trials, 15 days. Motion for costs is 30 days. And appeals are 30 days. Case management is 30 days. The pretrial conference is 20 days. Setting action for trials, 20 days. Setting the trial date is 30 days. And the demand for jury trial is 10 days. So just kind of rattled through some of them. We have them in the classroom, like detailed on a document that you could study. I do think that's an important thing to study right before the exam. And just to remind everyone, like, what some of the best resources. Let's say you go to civil procedure and then you look at criminal procedure. This is fine. These attack sheets, we have all the things that you need, like the first appearance within 24 hours. The speedy trial for misdemeanor is 90, for 175 for a felony. This is crim pro stuff, but this would be an example of that in the classroom. And then for civil procedure, I think, like these dates and times and these attack sheets, really solid stuff that we have here. They're super colorful. And if you're in my boot camp, I'm gonna have these printed out for the students to play with. Right. 20 days for a lot of these things, like the answer, 20 days. Intervention, these are some good concepts I could talk about. So intervention versus impleader versus interpleader. Impleader is bringing someone into the case. Intervention is a third party jumping into the case. And then interpleader is when two defendants litigate amongst themselves to determine ownership or liability. Cross claims versus counterclaims. Counterclaims are against the V. So if it's A versus B, B, counters against A. Cross claims are on the same side of the B. So it's A versus B and C. B would have a cross claim against C. These are some really good resources that we have. Remember, 120 days to serve the summons and complaint in Florida. 90 days in federal if you're taking the MBE. Okay. All right. See, this is my other edit that I made. So negligence would be, let's talk about torts now. So negligence would be duty, breach, causation, and damages. And we also talk about negligence per se. Negligence per se is when a statute determines a duty, and it has to be the designed injury and protected class. Intentional torts could be like assault, battery, false imprisonment, trespass to land, trespass to chattels, conversion, fraud, defamation of a public figure, IIED, intentional interference of a business relationship, malicious prosecution. These are some of the intentional torts, intentional endangerment, anything intentional. Try to throw the kitchen sink at them. That's what I always tell people about torts. Always write about negligence. Someone did something stupid. They're negligent design, negligent supervision, negligent training, negligent hiring, negligent premise liability, negligent design, negligent manufacture. Just like always someone did something stupid. But then add assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion. Like, think were there any intentional torts here? If there's ever an offensive contact, try to be like, Tommy will argue for battery because Susie fell into Tommy. However, this argument will fail because Susie, was slipped or whatever, it wasn't her fault. Like, whatever it may be, that's still gonna get you points. So IED versus NIED, the difference is intent. Florida usually requires a physical impact. So Florida does recognize the impact rule, but they've abrogated it, I would say is one word. They've curtailed it, meaning that you don't always need to have a physical impact for NIED, but just kind of argue the bystander rule that like they're a party that's a relative and they witnessed it and they're in the zone of danger. But the impact rule means that they had to have some physical impact, but they really have curtailed that. And the Florida bar has released some articles that I've read that make it pretty complicated, and I just gave you the best 20-second synopsis. Is they've curtailed the impact rule. Shopkeeper's privilege, that applies to false imprisonment, so they have the right to retain for investigation. Good Samaritan laws will protect rescuers from liability. So like, if you're trying to rescue someone, you don't have a duty to rescue them. And if you do rescue them, as long as you're not negligent in rescuing them, then you'll be shielded from liability. Medical malpractice, so you must follow strict procedures, including expert opinion and 90 days notice, meaning that you have to get an expert or third party to verify that you have a valid claim, and then you have to give them 90 days notice, and the doctor could choose either arbitration or mediation, and there's a limitation on the actual damages that they are entitled to. So res ipsa loquitur, the thing speaks for itself. So I think that the thing speaks for itself means that in the absence of negligence, this wouldn't have occurred. So like, if a pot falls off a balcony, then we know that how else would this person have, how else would the pot have fell if it wasn't negligently put up there? Right, I like what Grace said, it allows for the inference of negligence. So if the doctor left a scalpel in someone's body, well, then it has the exclusive control of the parties, and it led to injury. So that would be res ipsa loquitur. The thing speaks for itself. So punitive damages, I tell people, and it's in my book, like the first paragraph I write for torts is always mention these three things. The first is that Florida is a modified comparative fault state. I have that here at the bottom. The second is that Florida has abolished joint and several liability for negligence cases. And then finally, in Florida, the limitation on punitive damages is 3 times compensatory or 500,000. And then for torts, respondent superior comes up a lot, like a lot of essays. If you ever see like an employer or employee situation, you should argue for vicarious liability, respondent superior, the concept of frolic versus detour, where a frolic is, outside the scope of business, whereas a detour is, just within the scope of business. It's just slightly off track, and the employer would be liable for the detour, but not the frolic. So defamation, newspapers have 10 days to retract. So you have 5 days to provide notice if you've been defamed by a newspaper, and then they have 10 days to retract. And if they retract, then you can only recover actual damages. So libel is written or published, and slander spoken, and you should want to argue for slander per se, which would be crimes of moral turpitude, loathsome disease, a woman's chastity, or about a business, and distinguish between the private and the public plaintiff. The private plaintiff, you just need to prove negligence, whereas the public plaintiff, you need to prove actual malice. And then remember, true, right? Truth is a defense to defamation. If you called, Tommy a thief, but Tommy's been robbing liquor stores, then Tommy is a thief, and that's not defamation. Products liability, I have a feeling they're going to test this. I don't know why. I have a feeling they're going to test products liability, and we should be very confident in writing about products liability. I mean, not really. I don't know if they're going to test torts at all, but if they do test torts, I feel like products liability is due up. And remember, if there's a strict liability case, there's always a contemporaneous argument for negligence. They had a duty, they breached it, they caused damages, and causation was both proximate, foreseeable, and actual, but for. And then also argue the strict liability theories, that there was a design defect, that it failed the risk utility test. The risk of designing it one way outweighed the utility of designing it another, and consider alternative designs. Think of the manufacturing defect, where it wasn't manufactured properly, it wasn't created right, it came off the line different. And then express warranties like inadequate warning or failure to warn. And then implied warranties, merchantability, like it works or not, or fitness for a particular purpose. It works as it's specifically warranted to. So in Florida isn't a consumer expectation test for design defect. That is true. That's a good vocab word. I was saying in general, they use the risk utility test, but also Florida specifically uses the consumer expectation test. Like, was what the consumer expected met, and did it deviate? So what is a design defect? It's when someone, a supplier, manufacturer, producer, distributor, or retailer places a defective product in the stream of commerce. So if that happens, then they can be held liable, and anyone downstream. So, if you're just a component manufacturer and you make a good component, a good wheel, and then you give it to them and then they assemble it wrong, you're not liable. But once they assemble it wrong, anyone else, the car salesman and all those people could be liable, strictly liable under a design defect theory. And then, of course, I modified this PowerPoint to say that Florida is a modified comparative fault state, meaning that anyone over 50% at fault is barred from recovery. I actually had this presenter. If I seem tired, it's because I just realized I was at my networking meeting at 7 a.m. and then my boot camp at 10:30, and I was at the FedEx in between, and tutoring since then. But this morning, which seems like a week ago, the dude who presented was the personal injury attorney. His name is David San Pedro from Panther and San Pedro. They're on the radio. They're huge personal injury law. He's a pretty impressive PI attorney. He was showing like people with like their brains split open and stuff. I was looking away. I tend not to look at that stuff early in the morning. Like the dentist always shows like people's nasty teeth. I just like look down. I just don't want to start my morning off with nastiness. But anyway, the personal injury attorney, he asked for questions from the audience and me. I raised my hand. I was like, so how has your practice been affected by the changes in the reduction of the statute of limitations and in the change to modified comparative fault? And he was like, well, besides you just trying to sound smart and show off that you're the bar prep tutor, and I was cracking up because he called me out, but it was good. He said that, yeah, you know, they haven't been affected by the statute of limitations claim. And so, you know, statute of limitations claim for negligence cases is now 2 years from the cause of action instead of 4. He said that hasn't affected him that much, but definitely the modified comparative fault. And he explained kind of why the governor did it and what the intent was to lower insurance costs, but it hasn't really manifested in that. All right, let's talk about evidence. So evidence is tested. I'd say the chance evidence tested is like 83.7% on the test. It'll be a multiple choice subject, and it's tricky, right? In evidence, we have hearsay, an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. You know, a statement that from the neighbor that Johnny stole the cookies to show that Johnny stole the cookies is probably inadmissible because it's coming in to show exactly that. If it was coming in to show that, you know, the neighbor knew that Johnny had cookies or something, or like noticed, then that might be different. But if it's coming in to prove the truth of the matter asserted, it will be hearsay. There's certain things that are not hearsay, like prior inconsistent statement or admission by a party opponent. And then there's hearsay exceptions, like present sense impression, excited utterance, then existing mental, emotional, physical condition, medical diagnosis, business records, etc. Important to distinguish between exceptions where unavailability is immaterial and exceptions where they must be unavailable, such as the former testimony under oath, the dying declaration, the statement against interest, or the statement against the person who made the declarant unavailable. Really, statement against interest versus party opponent admission. Party opponent admission is non-hearsay, and then a statement against interest is when they're unavailable. So there's similar statements, but one of them is an actual party to the case, and we're gonna, you know, say it's not hearsay. At federal law, it's an exemption to hearsay. And then a statement against interest is going to be an exception, but they have to be unavailable in order to use it. So, you know, if you see the exclamation point, that's like the excited utterance or spontaneous statement. If you see, I intend to go to Georgia on this date, it's probably then existing mental, emotional, or physical condition, or state of mind actually is probably better. Medical diagnosis, it has to be for the purposes of seeking medical diagnosis, like what's wrong with you, Tommy? Oh, I'm bleeding from this gunshot wound, right? That's probably admissible. Business records, it can't be made in anticipation of litigation, so it needs to be like, you know, IBIS PREP, we do our payroll every Friday so they can you know, have evidence. Yeah, that's right. Our tutoring company pays out every Friday. If you know any really good tutors out there, we pay well, we pay often, and we have our tutors' backs. All right, so that's a little bit on evidence. Evidence can be a really tough subject. I mean, lay witnesses versus expert witnesses. We're going to use the Daubert standard. Expert witnesses, you know, they have to be qualified and have to have, you know, scientific expert knowledge. Lay witnesses can talk about things they have personal knowledge of. Florida evidence can be tricky. Something that we have in the classroom, and I think is important to look at, you know, down to the wire, I think would be right here, yeah, the Florida federal evidence outline. It's all the distinctions between Florida and federal, and there's a lot of them, and it can be really tough to test these back to back. So like Florida recognizes these privileges. Remember, Florida does not recognize the testimonial spousal privilege, but it does recognize the communications privilege. And then Florida doesn't recognize the learned treatise privilege either. Maybe something else we could talk about. Florida does not allow for opinion testimony to prove character, only reputation. That's like the big one that they super love to test. So this is a really important document that if you're taking both subjects, I would highly recommend you go over, and then, you know, Hannah made the super colorful one that I'm going to print out for people in the boot camp. Angie, you're really attending the boot camp live tomorrow, or that's been pulled back? Okay, so we have talked about evidence. Evidence is cool. Evidence is likely to be tested. What about real property? I think that's all right, good, Angie. I'll hold you to it. So if not, I'm gonna charge you for the printing expense. No, I wouldn't. I'm not a bad guy. I'd take on the risk of you not coming. Okay, so what about real property? Real property is an essay subject. We're going to talk about some essay subjects. We talked about torts, but let's talk about real property, con law, contracts, and family law and ethics. So deed formalities, in order for a deed to be valid under Florida law, it must be attested by 2 witnesses and contain an accurate description of land and be properly delivered. In order for a deed to be properly delivered, physical delivery is not required. So it has to be delivered in the sense that it leaves their control. Like, here, take this deed and record it when I die. That's going to be delivery. Recording statutes were a pure notice jurisdiction, so it protects subsequent bona fide purchasers without notice. So what are the different types of notice? Actual notice, inquiry notice, and record notice. So constructive notice. Actual means they literally knew about it. Inquiry means a reasonable inspection of property would have put them on notice. And then record notice means that it was in the recording documents. So bona fide purchasers are people who take for value without notice in good faith. Just like we talked about earlier with the holder in due course, you can, you know, really remember they have the same elements. A holder in due course is the same thing as a bona fide purchaser in terms of a commercial paper and real property. There's actually a holder in the ordinary course of business and secured transactions that actually exist too, but they don't really test that. Same exact concept though. Okay, so general warranty deed, you have upstream title clearance, where special warranty deed, you only have present title clearance, and quick claim deed, you have no title clearance. We said a general warranty deed has the 6 covenants, the present covenants of the right to convey, the right against encumbrances, and the right to seisin, and then the future warranties of quiet enjoyment, further assurances, and general warranties. JTROS, so each tenant automatically owns 100% of the asset when the other tenant passes away. In other words, the tenants survive each other. So you have to actually have words of survivorship when you create a JTROS. And remember, since Florida is a lien theory state, an encumbrance will not sever a JTROS. So the death of a party will not make it so that you can't recover from the other party if there's a lien on the property. They don't have title to the property. They just have a lien on the property if they're a lender. Tenancy in common, when one tenant passes away, her descendants or heirs inherit her properties according to the will. The tenants in common is the default form of ownership in Florida. So to the will or via intestacy. It means the heirs will take instead of the other partner. Florida's abolished the need for a straw man to convert a TIC into or to convert a tenancy into a tenancy by the entirety, which is basically just a JTROS plus marriage. The 4 unities of a JTROS are time, title, interest, and possession. So equitable servitudes versus covenants. Equitable servitudes are enforceable by injunction. Real covenants are remedied by money damages. You don't need privity for servitudes to run with the land. And servitudes are ownership interest in land, while real covenants are promises. The privity requirements have been relaxed too about the burden and the benefit, and that just know that for covenants and equitable servitudes to run with the land, there needs to be intent notice and it needs to touch and concern the land. Waste, so they test this a lot. Permissive waste, just letting things rot. Actual waste is like punching a hole in the wall. And then ameliorative waste is beneficial but still waste. This will apply to life estates and will apply to tenancies, like a landlord-tenant situation. Be prepared for the landlord-tenant essay where you have to write about the duties of habitability and quiet enjoyment, and then to pay rent and to maintain the premises and things like that. When you get that landlord-tenant essay, just put yourself back in a year ago when you had a dispute with your landlord, and just kind of write it out from that perspective. Adverse possession, that's acquiring title via squatting rights. Don't write that in your essay. That's not the most articulate way, but it's acquiring title via hostile, open, continuous, exclusive, actual, and notorious use of the land. The period for adverse possession is 7 years in Florida. It's 20 years for a prescriptive easement. And easements could be express, implied, by necessity, by prescription. They could be appurtenant, engross, negative. You can cite the Fontainebleau case, Fontainebleau versus Eden Rock, to mention that Florida does not recognize an easement for light or air or view. Right? Florida's a lien theory state. Talk about mortgages. A mortgage on a property is a loan secured by land, and in the event of default, there can be a foreclosure, which is the forced sale of a property. The senior mortgagees will get paid off by the foreclosure sale. There could be an equitable right of redemption before the sale or statutory right of redemption after the sale. If the foreclosure sale doesn't pay off the senior mortgagee, or there's junior mortgagees, they'll need to seek a deficiency judgment from the mortgagor, which would be personal. Overuse of an easement tends to lead to a surcharge or an injunction. Termination of an easement can apply via, merger or agreement, or
Abandonment.
abandonment. Nice. All right, so real property is tough. I think of all essay subjects, real property is probably the toughest. My year, February 2017, they hit us with a super hard real property essay, but to make things better, they hit us with a really hard Florida common law essay as well. Okay, so contracts, I think contracts is like, torts is always, I score the best on torts in the bar exams I've taken, but contracts, I think I have the best, blueprint for. And someone was giving me credit for the other day. They said they can't stop thinking about it. They said, we said, buy friends drinks, big drinks. And I told them, I am friends. Find me at American Social at 5:30 on Wednesday. And stay true to this mnemonic. Buy friends drinks, big drinks. Body of law, formation, defenses, breach, damages. Right? Body of law, formation, defenses, breach, damages. So Article 2 is for goods, common law for services. Goods are all things movable. Offer, acceptance, consideration, no valid defenses, necessary terms. Offer, acceptance, try to use the words intent to be bound by, mutual assent, meeting of the minds. Consideration, bargain for exchange of legal detriment or value in Florida. No valid defenses. I mean, defenses, we see all the I's down here. Infancy, incapacity, insanity, incompetency, impossibility, undue influence, intoxication, unconscionability. Then there could be duress, fraud, misrepresentation, mistake, unilateral versus mutual. The main defense that they always talk about is the statute of frauds. So marriage, contracts that cannot be completed within 1 year, contracts for land, executorship, goods over $500, suretyships, contracts for healthcare guarantees or life insurance in Florida. So there's also the mnemonic swap, which is exceptions to the statute of frauds, especially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. For land, you actually need all three in Florida, which is improvement, possession, and payment. Look for partial performance, look for promissory estoppel. I think a lot of people don't write about them on exams. So, you kind of just march through this, like, are they merchants? What are the special rules that apply to merchants? If it's UCC, we'll use the firm offer rule. So an additional term will be part of the contract unless it materially alters the contract. And if so, we'll use the knockout rule and UCC gap fillers will apply. Under the common law, we use the mirror image test. And then when it comes to contract formation, under the UCC, will require perfect tender. Under common law, it'll be substantial performance. So I said promissory estoppel and partial performance. Those are two concepts that come up a lot on contract essays that people miss out on, I would say. They also miss out on damages. Everyone gets smoked on damages. So again, the battle of forms provision amongst merchants, the term is included if it's not material. The mailbox rule and acceptance of an offer is generally effective upon dispatch. Terminations are effective when received. Offers are effective when received. Anticipatory repudiation, so a party can sue based on knowledge. Like, if you know that one party is not going to honor the contract, you can sue under the theory of anticipatory repudiation if they unequivocally demonstrate intent not to enter into the contract. Look for things like non-compete agreements. They need to be reasonable in geographic scope and subject matter and duration. Look for, modification under common law. We need consideration under the UCC, just good faith. Look for installment contracts where a non-conforming shipment or non-conforming performance won't give rise to a material breach because there will be an opportunity to cure in a subsequent installment. Look for liquidation, a liquidated damages clause, which means that the parties have agreed to damages ahead of time because they'd be too speculative in light of a breach. What are the different types of legal remedies? So they could be punitive or compensatory. Punitive are very rare in contract law. Compensatory would be expectation damages to put the non-breaching party in the position they'd be if the contract had been performed. Consequential damages, which are foreseeable in light of a breach. Incidental, which are damages that are for mitigation costs or for recovering for the breach. There's lost wages, lost profits, reliance damages, which are associated with promissory estoppel and such, and restitution to disgorge ill-gotten gains. Nominal damages in name only. Then there's equitable relief, like specific performance, injunctive relief, rescission, reformation, replevin, promissory estoppel, quasi-contract. A lot of different types of relief. The main ones are expectation damages and specific performance, right? Expectation damage to put them in the position they would have been if the contract was performed as expected, and specific performance for unique goods, land, or art. Rescission is putting the parties in the position they were before the contract, like pretty much ripping it up. And then reformation is modifying or editing the contract. So I think we could do really, really well on a contracts essay. Maybe look out for accord and satisfaction, which is an agreement to pay off an old debt with a lower amount. Third-party beneficiaries, people whose rights can vest and they can enforce the contract if they, have rights or interest in the contract intended versus incidental. But mainly it's going to be statute of frauds, battle of forms provision, perfect tender rule, mirror image test, just try to use the main buzzwords. All right, family law. Oh, this is the one thing that I did need to try to edit. I forgot, which is Florida does not recognize permanent alimony anymore. Florida only recognizes durational. And we've changed it from 7 to 17 to 10 to 20. So short-term marriage is 10 to 20. Long-term marriage is, I'm sorry, short-term marriage is under 10 years. Long-term marriage is over 20 years. Okay, so in Florida, the court will file the best interest of the child standard in determining the time sharing of the time sharing agreement. Florida prefers to grant both parents shared parental responsibility. And generally they grant the primary residential time sharing to one parent and liberal reasonable visitation to the non-residential parent. This is a constitutional right in Florida, the right to the upbringing of your child. So unless there's, deviating factors, both parents will be allowed time sharing rights to the children. A spouse who is a resident of Florida for at least 6 months prior to petitioning for divorce may petition the court for divorce on the following grounds: the marriage is irretrievably broken, or the spouse has been adjudicated mentally incompetent and has remained so for the past 3 years prior to petition. Upon the petition for divorce, the court is required under Florida law to distribute the marital assets under the Florida Equitable Distribution Doctrine. In order to do so, the court must first distinguish between marital and non-marital assets. The court must divide the property equally. The court must divide the property equitably and will generally attempt to achieve a 50-50 split. Half to each spouse. However, the court may alter distribution percentage if equity so requires. And then the different types of alimony, I meant to doctor this up a little bit, but let me just tell it to you off, my understanding. There's going to be temporary alimony, bridge the gap alimony, lump sum alimony, pendente lay alimony, and durational alimony. We no longer have permanent alimony. So temporary, it's also called Ramel said pick better relationships, so pendente light, bridge the gap, rehabilitative, and durational. I like that. So temporary is during the pending divorce proceeding, so it could be pendente light or temporary, up to 3 months if the court extends for contested proceedings. Lump sum could be just a big amount, for their expectancy. And then rehabilitative is designed to reimburse the spouse for illness or education. If the spouse gave up work or schooling for marriage, they may be reimbursed so they can re-enter school. And then this durational is what's replaced permanent, or what they have, not replaced, but is the longest you can get. It depends on, the length of the marriage and all these different factors. I would also tell people that you could be grandfathered into permanent alimony. Like if you got permanent alimony 10 years ago or 5 years ago or 2 years ago, even, you could still continue to have permanent alimony. We have the mnemonic JV Peast with a side of mustard or something, or MJV Peast, which is like jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, esquire fees, divorce, and modification. And if you can kind of just think about all those points, you should be fine. And then adoption comes up sometimes, like, if you're put up for adoption, the biological parent loses rights. There's rights that the grandparents have. I mean, the parents have priority rights, but the grandparents do have constitutional rights to take the child before they're, given up for formal adoption. Yeah, it's if you haven't been married, if both of you said this, what are you guys talking about, arguing about? 3 years, no alimony. If you're married for less than 3 years, you're not going to be able to get durational alimony. Yeah, and again, these are all just factors. Like the court could decide things, and when it comes to child support or alimony, there's statutory guidelines, and then they would need to show extenuating circumstances to deviate over 5% from those statutory guidelines. Another thing to consider is that they'll do what's in the best interest of the child, and you will argue all the different factors for why they should get alimony or why they should get child support. But remember, in a prenuptial agreement, you cannot waive child support. You could potentially waive alimony, but you can't waive child support. Okay. And then we have ethics. So the ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. Noncompliance could lead to fines, suspension, admonishment, or disbarment. What are some type of things that we talk about in ethics or referral fees? Any agreement to share money with another law firm must be in writing, signed by the client, stating the terms of the arrangement, and in most cases, making the parties jointly or severally liable, or defining the arrangement by the amount of work done. So typically for referral fees, they're disallowed in Florida unless you have consent with the client and both lawyers participate in the representation. The business transaction rule, the lawyer cannot engage in a business transaction with the client unless the lawyer makes a full and fair disclosure of the terms of the deal, confirmed in writing, the deal is fair and reasonable to the client, and the client is informed of the desirability of seeking independent counsel with respect to the transaction. We should think about the duty of confidentiality. This one's tested so often: conflicts of interest, duty of competency, duty not to commingle funds, and improper purpose. So conflict of interest, try to think about imputing the conflict to others. Think of screening the lawyer out of the conflict, and remember that you can still take on the representation if you have consent from the client and you reasonably think that you can represent the client without being professionally compromised. Duty of confidentiality is even greater than the attorney-client privilege, which is an evidentiary rule. The duty of confidentiality survives the representation and even death. Honest and effective communication, adherence to a fundamental sense of honor, integrity, and fair play, commitment to equal justice under the law and the public good, commitment to the just, speedy, and inexpensive determination of every controversy, which is necessary to preserve our system of justice. So no frivolous claims. When lawyers display reverence for the law, the judicial system, and the legal profession by acting with respect, decorum, and courtesy, they earn the trust of the public and help to preserve faith in the operation of a fair judicial system. Respecting the time and commitments of others is essential to the efficient and fair resolution of legal matters. An enduring value of a lawyer's service is grounded in the lawyer's willingness to exercise independent judgment and practice, and while giving the client advice and counsel. Also think about contingency fees, right? They need to be in writing, and they need to have consent from the client, and they need to show the client how they're going to be calculated in advance and give them a final calculation before they're paid out. They're not available in criminal or domestic cases. Some of the main things tested in ethics. Just remember, I think everyone should have this statement in their head as they're walking into the bar when everyone else is freaking out and being weird. Just say this calmly over and over your head, and then right when the test starts, just write it down on your paper, because it's going to appear on some essay, and you might as well copy and paste it where you need it. All right, so I think we have last two slides: Florida and federal con law. I would say these could be the most important subjects, because they're the most heavily tested essay subjects besides ethics, but ethics is only tested partially. These subjects, con law, are tested in totality. It doesn't look like I did a Fourth, Fifth, Sixth Amendment slide, so let me just talk about that quickly. We need to be comfortable writing about this. This is always a subject I kind of like take for granted, thinking that like, okay, you went to law school, you watched some movies, everyone should be good at writing about this essay but they've tested it more and more often than ever. And I'd be remiss if I didn't talk about it. You need to be confident with the Fourth, Fifth, Sixth Amendment. Fourth Amendment is your right against unreasonable searches and seizures. We need to know the exceptions to the warrant requirement. I use the spaces mnemonic, search incident to arrest, plain view doctrine, automobile exception, consent, accident circumstances / hot pursuit, and stop and frisk. Those are times when you don't need a warrant. A warrant is issued upon probable cause by a neutral magistrate and it has to particularly describe the items being searched or the person being arrested. There's the concept of the exclusionary rule and the fruit of the poisonous tree doctrine, meaning that anything seized unlawfully in violation of the Constitution will be suppressed from evidence, and anything that's found as a result of that unlawfully seized evidence will also be excluded under the fruit of the poisonous tree doctrine. You have to know the concepts of a custodial interrogation, Fifth Amendment, Miranda rights. So if you're in custody, they have to read you your Miranda rights before they do a interrogation. And then you have the Sixth Amendment right to counsel, which is your right to counsel after adversarial proceedings have begun. If you could really just, kind of flesh it out, talk about Fourth, Fifth, Sixth Amendment, I think you'll do just fine on those essays. All right, so Florida con law, we have the homestead exemption. Homestead is defined as up to half an acre of land in a municipality and up to 160 contiguous acres of land outside a municipality. The Florida Constitution expressly gives rights to spouses and minor children under the homestead provisions, and the provisions are designed for the protection of spouses and minor children. A person may only have one homestead and must establish the homestead by showing the home is the primary residence, voter registration, etc. A homestead property, even if owned solely in one spouse's name, may not be conveyed or devised away from the other spouse or the spouse's minor children. Any conveyance of an interest in a homestead property must be consented to by both parties. If not, the conveyance is void. Homestead properties are shielded from judgment creditors, except for taxes or judgments from the government, or actual encumbrances on the property, like mortgages, liens, homeowners association fees, the lawyer who procured the homestead, or mechanics liens or construction liens, things like that. So sunshine laws, I think my prediction, and my prediction is just a prediction because that's all it is. It's very mathematical. I teach math. Can't wait till August when I can stop teaching the bar and just teach normal subjects again. But no offense. But mathematically, my prediction is a Florida con law essay that's just like this slide: homestead, sunshine law, making an act of law, general law, special law. Like this slide, I think is likely to be tested, in my opinion. Not likely, but it's just my prediction. Don't say likely, Andrew. I think my prediction is this slide. My prediction is property, pretty ugly property essay, and then family law. And that's just based on last time they did contracts, torts, they did like federal con law, and they did like that Crim Pro 4th, 5th, 6th Amendment one. So like just kind of thinking they didn't do family law, they didn't do property, they haven't done Florida con law in a couple times. That's just what I think is coming, but it's probably not going to be those three. I mean, most likely not going to be those three. It could easily be torts contracts. It could easily be federal con law, and it could definitely be the con crim law one. But I'll promise you one thing: they will test ethics. Okay, so sunshine law, I think, is likely to be tested. Florida government, the sunshine law provides a right of access to government proceedings at both the state and local levels. It applies to any gathering of 2 or more members of the same board to discuss some matter which will foreseeably come before the board for action. So the exception is if it's only 2 legislators, not including the governor. for unplanned meetings. So for the bill act formalities, it needs to have an enacting clause. It needs to have a single subject. It needs to have a clear title. It needs to be related to the health, welfare, and morals of the people of Florida. It cannot be vague nor overbroad. It needs to conform with the elements of bicameralism, meaning it's read into each house 3 times and presented to the governor for signature. General law applies to the state populace at large. Special law applies to a particular class or location or county. And then general laws of local application or population specific. Note that special laws are subject to a vote or referendum. Local taxes could be like county taxes, school districts, municipalities, or special districts. Municipal taxes could be general obligation bonds or revenue bonds. So these are not necessarily taxes, but they're also municipal measures. Could be the issuance of revenue bonds or general obligation bonds. General obligation bonds are backed by taxes, and revenue bonds are backed by the revenue of the actual project. A general obligation bond would be like building a school or a park. A revenue bond would be like a toll bridge or an airport that pays back money. Ad valorem taxes or property taxes. Note that only counties or municipalities can issue property taxes, not the state. The state of Florida cannot issue property taxes. Look out for like Pfluger doctrine for Florida con law. That's a law that allows for the state to restrict the right of access. Note that in Florida privacy, there's a heightened right to privacy. It's an express right. Look how sunshine law, defamation, right to privacy, all those things could kind of come together. And right to privacy, torts could be like intrusion upon seclusion, appropriation or misappropriation, and public disclosure of private facts. Florida con law, super tough subject. Look for like separation of powers. Who are the constitutional officers? Like who could become a senator? You have to be like 18 years old, normal things. Separation of powers, usurpation, encroachment, entanglement, entwinement. Make sure that the person who's making the state action is vested with the right to do so. So federal con law, I always tell people con law essays, you want to start with standing, state action, and justiciability. Standing would be injury, causation, redressability, and then justiciability would be that it's ripe and not moot. State action, there has to be some state action to implicate the Constitution. And then standing, state action, justiciability, right? Now, what's most heavily tested in terms of the amendments? 1st, 5th, 14th. First is there's 5 things on the 1st and 5 things on the 5th. Let's try to remember that. The 5 things on the 1st are the freedom of speech, freedom of religion, freedom of press, freedom of assembly, and freedom of petition. Freedom of the religion could be free exercise and free establishment. Freedom of speech could be content-based or content neutral, time, place, and manner. It could be public forum, limited public forum, non-public forum. All these things I talk about pretty nicely in my book that I think you should all read before the test one last time. I think that there's unprotected types of speech like hate speech, speech that's likely to incite imminent lawless activity, defamation, false or misleading commercial speech, or obscenity, which is speech that appeals to the prurient interests of mankind and is devoid of any literary or artistic value. That's First Amendment. Fifth Amendment, the 5 things on the Fifth Amendment are the takings clause, due process, the right to counsel, Miranda rights, your right against self-incrimination, and your right against double jeopardy. So we definitely want to know the scrutiny levels. Well, also 14th Amendment. 14th Amendment is equal protection, suspect classes. So, you want to know the fundamental rights apply to the right to vote, the right to work in Florida, the right to be in a union, like we said, the right to privacy, all these fundamental rights, contraception, marriage, procreation, education, the right to raise your children, access to courts, due process. So there's procedural and substantive due process. Procedural due process is notice and hearing. Substantive due process is that they're not depriving you of your rights. Equal protection is when a specific class is being targeted or discriminated against. So race, alienage, national origin is strict scrutiny. Intermediate scrutiny could apply to gender-based discrimination or illegitimacy, and then rational basis will apply to age, wealth, or everything else. It's also important that disability is subject to strict scrutiny. So race, alienage, national origin, or disability. Definitely know the strict scrutiny must be narrowly tailored to achieve a compelling interest. Intermediate scrutiny must promote an important interest and be substantially related. And then rational basis must be rationally related to a legitimate interest. The burden of proof is on the government for strict scrutiny or intermediate scrutiny, and it's on the plaintiff for rational basis. I think these terms come up in like every common law essay. They usually give you a statute or ordinance and want you to attack it. And one way to attack it is usually that it's vague or overbroad. A statute is too vague if people of common intelligence would have to guess at the statute's meaning, and it's overbroad if it's not sufficiently restricted to a specific subject or purpose. Due process is a legal requirement that requires a state to respect all the legal rights owed to a person. Standing, injury, causation, redressability, right but not moot. Equal protection, 14th Amendment protects individual rights. Privileges and immunities under Article 4, it prevents a state from discriminating against non-residents. And then the Commerce Clause. So the Commerce Clause allows the government to regulate the channels, instrumentalities, and economic activities that in aggregate have a substantial effect on interstate commerce. And the Dormant Commerce Clause prohibits the state from enacting legislation that would unduly burden interstate commerce on its face or via balancing test. They could test like the Commandeering Clause, like the federal government is forcing the state to enact legislation. They could test a lot of things. I think separation of powers comes up a lot. Be on the lookout for, oh, is this a violation of separation of powers? They're vesting rights or usurping rights from one branch to the other. Access to courts for sure comes up a lot. And like I said, the Kluger Doctrine is the doctrine in Florida that allows the state to restrict fundamental rights if there's an overarching necessity. I mentioned the Kluger Doctrine as a case. Rosen v. Rosen is a case that says that you can get attorney's fees in family law cases. We mentioned Fontainebleau versus Eden Rock as a case for potentially talking about your lack of a right to air or view. And then a major case in Florida, a groundbreaking case, would be Johnson v. Davis, which is the duty to disclose when it comes to residential real property. And you could write about concealment, fraud, or misrepresentation, or things like that. Remember, on these essay subjects, they have complete liberty to test 2 or 3 different topics, contracts, real property, ethics, all in one essay. So just write your little hearts out. When in doubt, write it out. Try to give them the kitchen sink. Try to elaborate. Try to really do your best. The Florida bar exam is extremely difficult, but it's super passable. I went to law school, and I know there's a 0% chance they would ever watch this if it's on YouTube or ever in life. So I say their names proudly. I went to law school with Tim Fitzpatrick, Ryan Bermudez, Zaylen Bajor, 3 regular idiots who passed the bar exam on their first time, and I can't imagine they studied incredibly hard. I'm sure they studied properly. James Klein is another of my idiot friends who passed this test, right? It's a very passable test. So just be confident that it's super passable. And if you're a retaker, your worst enemy is yourself in terms of your own self-doubt. but retakers should feel confident because you started with such a great foundation, and now you spent the past couple months or whatever it may have been just filling in the blanks, dotting your I's, crossing your T's. So I think this was a really great review. I know we went overtime, but you know that's my specialty. Even though Angie was making fun of me at the beginning, I always finish strong. And that's something I'll tell everyone on test day. Finish strong. Most people die within a mile of being saved. The quote today, this morning, that they told me was, you know, and this is from Maslow, who's the hierarchy of needs guy. He said that if you dropped me into the ocean and told me I had 1,000 miles to swim, I would keep swimming, and I would come to despise anyone who gave up. And that's a great attitude. Like, this is a hard test, but let's just give it everything we've got. And, I don't want anyone in there to be that person who gives up. I think we can all pass this test. And I think a lot of you can pass it with flying colors. So thank you all so much for joining me for this review. There will be one last review on Saturday at 11 a.m. It'll be much more chill, a lot more interactive, but I wanted to make sure I did a comprehensive review. So I'm going to go ahead and stop this recording.